South Africa bolsters business framework and corporate transparency with new legislation. By Satori News. In a substantial leap forward for corporate governance and the ease of doing business in South Africa, President Cyril Ramaphosa has ratified sweeping amendments to the Companies Act of 2008, ushering in a new era of transparency and accountability. The Companies Amendment Act and the Companies Second Amendment Act are seen as game changers, easing corporate regulatory burdens while demanding greater clarity on pay gaps within companies. These changes will streamline company law, making it clearer and more user-friendly, significantly altering South Africa's corporate landscape. A key aspect of the legislation is the focus on wage disparity, with public and state-owned companies now mandated to produce an exhaustive remuneration report detailing the salary structures across the spectrum of employment, from the highest to the lowest paid employees. The intention is to spotlight disproportionate earnings and bridge the expansive inequality prevalent in society. The remuneration report, a critical element of the Act, aligns with global trends demanding heightened corporate responsibility and ethical conduct by requiring detailed reporting on all directors and prescribed officers' pay packets. It must also disclose the mean and median employee earnings and the remuneration range within the top and bottom 5% of the company's wage earners. Beyond addressing pay transparency, the laws extend the arm of accountability, enabling legal proceedings against delinquent directors or prescribed officers well beyond the earlier prescribed limits. This embodies the South African government's commitment to combating corruption and malpractice in the corporate sector, with provisions shaped by recommendations from the State Capture Commission. Another welcome provision permits the courts to validate the issuance of shares, fostering further legal assurance within corporate dealings. These measures are not simply legislative tweaks, but represent a significant stride towards a more ethically grounded and investor-friendly business environment. By cutting red tape and laying a solid foundation for transparent corporate conduct, South Africa positions itself as a more appealing destination for both domestic and international investors. Additionally, the new laws are set to have implications for corporate actors, reinforcing the notion that unethical and illicit activities will face rigorous scrutiny. The implications for corporate governance are profound, boosting stakeholders' confidence and ensuring a fairer distribution of economic benefits. While the focus is to ease business proceedings, the amendments are equally invested in delivering justice and maintaining an equitable corporate sector. The expansion of the time frame to declare a director delinquent from 24 months to 60 months provides ample time to correct past wrongs and fortify corporate discipline. Overall, the twin bills signify a proactive stance by the South African government to align its corporate laws with global best practices, ensuring a balanced and equitable playing field for all stakeholders involved in the economy. Thank you for choosing Satori News.